Good afternoon, ladies and gentlemen. Thank you so much for joining us today for the second in our two-part series of discussions on Amicus Curiae, the power and potential of non-party briefs in advocacy in Rwandan courts. My name is Jeremy Jewett. I am the Acting Public Affairs Officer at the U.S. Embassy here in Kigali, Rwanda. Thank you so much for joining us today. At the top, let me give a big thank you to our colleagues in the political economic section here at the embassy and our counterparts at the Rwanda Bar Association who have helped organize and co-host this discussion series. For those of you who are joining us for the first time this week, we do have a few notes at the top. The first is a reminder that today's program will be recorded. Please keep that in mind over the course of the conversation, and we'll also make these video discussions available both on the Embassy YouTube page and on the RBA website for your review or consideration after today's program as well. For RBA's record keeping for continuing legal education credits, please do take a moment to update your username or your screen name. It will be difficult, for example, for RBA to give CLE credits to HP. And yesterday we had someone logged in, last week we had someone logged in as iPhone. Please do update your names there so that you can get CLE credits, if applicable, from the RBA. A reminder that we welcome and encourage the use of the chat box for any questions that you have over the course of today's program. You would also be more than welcome to raise your hand or come off of mute to ask a question once we move on to the question and answer portion of today's program. Before then, though, please do make a point to mute yourself so that everyone can enjoy the program. If there are folks who are not on mute, I will do my best to put them on mute from my end as well. We will also be asking a series of poll questions over the course of today's programs. You'll see that as a built-in feature into the Zoom. We welcome and appreciate your thoughts and feedback to any of those questions over the course of our polling. That helps us evaluate our programming and consider future programming going forward. That aside, welcome once again to the second of our two programs. If you missed the first program, there will be a tape recording of that. We're looking forward to a great follow-up conversation today. We are excited to have on our program two fantastic attorneys. It will be a pleasure to introduce from the United States, attorney Dwayne Sam of Womble and Dickinson. In addition to representing clients in complex proceedings concerning communications law, constitutional issues, and interpretation and enforcement of federal statutes and administrative law, Dwayne also serves as an adjunct professor at William & Mary Law School, where he co-directs the Appellate and Supreme Court Clinic. After Dwayne's 30-minute presentation on best practices in Amicus Curiae advocacy, it will be a pleasure to introduce Floyd Kabasinga, a founder and managing partner of Certa law firm here in Kigali. Florida has almost 2 decades of experience in the fields of international criminal law and domestic, commercial, and criminal justice in Rwanda. In addition to holding, and this is of course always our favorite part coming from the U.S. Embassy, a Master of Laws degree in international human rights law from the University of Notre Dame in Indiana in the United States. Following both of those presentations, we will move to a combined question answer where you'd be welcome to steer your questions either to Dwayne or to Florida, or to anyone joining us today who has experience in the field of Amicus Curiae. At the conclusion of today's program, we'll be delighted to welcome Ambassador Vrooman for a few conclusionary remarks and perhaps a few questions that he may have for you all based off of your experience in the discussions this week and last week, or your legal practice here in Rwanda. Thank you once again for joining us. And without further ado, it is a pleasure to introduce and welcome for the second time, Dwayne Sam. Welcome back, Dwayne. Thank you so much for joining us today.
Thank you. Good afternoon, everyone. Thank you for the warm welcome and introduction, Jeremy. So just wanted to do a brief recap for those of you that weren't able to attend the presentation last week. Obviously, we've been discussing Amicus Curiae briefs, and the presentation last week sort of touched on the history and usage of the briefs in the US legal system. And we talked about the origins of Amicus Curiae briefs and how it dates back to Roman law, how its usage first began as really sort of a neutral bystander in the court whose primary objective was really to aid the court in its interpretation and adjudication of whatever the dispute involved, but how over time the usage really sort of evolved to be more partisan and take on more of an advocacy role for a particular interest or individual. We also spent quite a bit of time talking about how the briefs have really seen a dramatic rise and have really sort of risen to primacy in American jurisprudence and really sort of charted the course over the last 200 years since the first amicus brief was filed, and looked at some of the numbers regarding just the sheer volume of briefs, particularly in the Supreme Court, noting, for example, that it's not at all uncommon now to see amicus curiae briefs being filed, sometimes 80 plus briefs being filed in many of the most contentious cases in American law before the Supreme Court, and sort of contrasting that to some of the earlier cases that were also well known, say, for example, Brown v. Board of Education, where, less than a dozen briefs are filed. And so it really, that sort of contrast really just sort of underscores just the relevance and the ascendancy of amicus briefs in legal practice in America. We also touched briefly on what has become, what has come to be known as sort of the quintessential amicus brief, which is to say the Brandeis Brief, and just sort of touching on how the Brandeis Brief was a pioneering legal brief that was the first in the United States really to rely more on a compilation of scientific information and social science than legal citations. And we also talked a little bit about the parties that have found the most success before the Supreme Court, and success being judged and assessed in terms of the degree to which the Supreme Court will cite to the particular amicus brief in a written opinion. And so, having recapped that, I guess I think the next logical step then is to talk a little bit today about what can we do as practitioners what are the best practices that we can adopt in filing and in drafting our own amicus briefs? What should be sort of top of mind? What should we be thinking about? What are the rules of engagement? Interestingly enough, although last week's presentation really focused on Supreme Court practice, I think the most sort of salient and comprehensive guidance that I've seen on amicus practice has actually come out of a federal appellate court here in the United States, as opposed to the Supreme Court. Federal Rule of Appellate Procedure 29 governs the filing of amicus briefs in appellate courts. And that rule permits the United States, a federal officer or an agency or a state to file an amicus brief. Any other party may file an amicus brief only with the consent of all parties to the appeal or with leave of court. And under the federal rules, a motion for leave to file must identify the interest of the movement and state why the filing of the amicus brief is desirable. It must also disclose whether the party's counsel authored the brief in whole or in part or funded preparing the preparation of the brief. Notably, however, Rule 29 does not define the circumstances in which a court will grant leave to file an amicus brief. And so notwithstanding, the ascendancy and primacy of amicus briefs in American legal practice, judges have differed on whether and when briefs are useful. So for example, Justice Stephen Breyer, for example, has publicly commented on their important role in educating judges on potentially relevant technical matters. But Judge Richard Posner, who's a notable jurist here in America, has lamented the tendency of amicus briefs to sort of duplicate and be redundant of arguments that are made in the litigants' primary briefs on the merits. That said, there's a recent Seventh Circuit opinion, appellate court opinion out of the Seventh Circuit that has provided helpful guidance, I think, additional guidance for litigants on how to draft amicus briefs. And that's really what I want to spend my time talking about today. That particular case called Prairie Rivers Networks, v. Dinergy Midwest Generation. In that case, Judge Michael Scooter Jr. issued an in-chambers opinion permitting the filing of 3 amicus briefs in an appeal addressing whether the Clean Water Act regulates groundwater. And in the process, Judge Scooter provided, I think, key guidance on when an amicus brief is beneficial to the court's decision-making process. In particular, Judge Scooter stressed that an amicus brief should not merely be a copycat brief, but should seek to add value and really strive to offer something different, something that's new, something important. In particular, and I think really sort of valuable guidance, Judge Scooter listed 8 specific ways in which an amicus brief might assist the court. And those are the ways that I'd like to sort of unpack for you today. And these are suggestions that I think that I've found useful, not just from a theoretical perspective, but experientially as well. So to begin, I wanted to talk about the first sort of key insight, which is that the amicus brief should offer a different analytical approach to the legal issues before the court. So what does that mean? There are often numerous legal issues at play in a particular legal dispute. There are lots of different perspectives and avenues that you can view the case from, and oftentimes, given the word limits in briefing and space constraints, the parties address the issue sometimes too narrowly or not broadly enough for the court's benefit, and they maybe zero in on a particular legal issue, but to the detriment of other legal issues. And so one way to add value to the court, and one way to sort of enhance the court's knowledge dealing with a particular case, is to provide a different analytical approach, to suggest to the court a different legal lens through which you can view a particular dispute. Perhaps instead of looking at the case through maybe, here in America, for example, perhaps looking at the case through civil law, you're looking at the case through sort of traditional American jurisprudence. Perhaps you're looking at the case through international law, for example, or maybe you're looking at the case through a corporate perspective instead. But the goal here being that you really want to look at the case and consider whether there is a different analytical approach to the legal issue that can provide some value to the court, and that can really get the court thinking about a different way to approach and adjudicate the dispute. A second key insight, I think, would be highlighting factual, historical, or legal nuance glossed over by the parties. Oftentimes there are details that there are lots of different facts in a case, and many of them can sort of fall through the cracks or get lost, I think, during the course of presenting legal argument. Again, a lot of this really comes down to space limitations. You obviously can't make every single argument in a merits brief and unpack them oftentimes to your satisfaction, or at least the parties in the merits can't do that. And that's where an amicus brief, I think, can provide some value by zeroing in on factual disputes that maybe didn't get the sort of attention that they needed, or providing sort of a historical context, maybe talking about how the law was developed over the last several decades, or how the law has evolved recently. Other legal nuance in the cases that the parties aren't bringing to the court's attention. Sometimes that could mean sort of unpacking and presenting, putting more meat on the bones in a footnote that the parties had in their merits briefing, right? Sometimes footnotes are used to maybe just bring to the court's attention briefly issues that the parties don't have adequate space to address in full. But that's where an amicus brief can provide value by unpacking that and enlarging the scope of the arguments that were presented to the court. The third way is through, I think, explaining the broader regulatory or commercial context in which a case comes to the court. A lot of these cases, many cases, I think it's fair to say, do not occur in a vacuum. And there are other key commercial and regulatory concerns. It could well be the case, for example, in an administrative law case or a regulatory case, that there are other perhaps pending rulemakings or pending administrative issues that the court should be mindful of, that may in fact impact and should impact its analysis and its consideration of the legal issues. That's another way in which the court could benefit from amicus briefing. The commercial context, right? What are the particular consequences commercially of taking a particular legal action? How might particular industries be affected by the court's ruling? What may be the financial fallout, or does someone stand to benefit from a financial windfall from the court's decision? All of these things, don't necessarily get the sort of treatment that they deserve in merits briefing, but certainly an opportunity exists, I think a fertile one, for unpacking the commercial context and broader regulatory concerns that a particular legal issue may implicate. The fourth sort of strategy that you may want to use when you're drafting an amicus brief is providing practical perspectives on just sort of the consequences generally of the court's decision, right? When we're talking about appellate courts, one thing to keep in mind, and I think one thing that is easy to forget, and also one thing that sort of makes appellate courts different from district courts, is that district courts or trial courts are often concerned with the case at hand and just adjudicating that particular matter. Whereas in contrast, appellate courts are often concerned with what the subsequent implications will be, not just for the parties, but for subsequent parties that may come before them. How is this case going to affect the public at large? What are the broader legal implications? What are some limiting principles that we can adopt in our decision-making process? What else should we be thinking about generally? And that's where amicus briefing can really sort of shine. And this is really one of the areas, I think, where the quintessential Brandeis Brief often shines, which is by when you're providing that sort of factual and scientific information, it can really sort of bring to bear, just how the court's decision can be consequential, not just from a legal perspective, but from a social science perspective as well. And that sort of, I think, parlays nicely into the fifth point, which is sort of relaying views on legal questions by employing the tools of social science, right? What have sociologists had to say about a particular issue? If we're talking about gay marriage, if we're talking about violent video games, if we're talking about the legalization of marijuana, if we're talking about school choice, if we're talking about prayer in schools, a lot of the hot button controversial issues, this is an area that is ripe for amicus participation, and it's a great opportunity to help sort of distinguish your argument and to distinguish your position by invoking that social science and relying on those tools to really help shape the court's perspective on what the legal issue is, and giving them just another lens, again, through which they can view these issues, right? Again, because appellate courts are ultimately concerned, I think, with crafting a legal decision that addresses not just the issue before the court for the particular case, but also for the cases that will come before it in the future. These additional lenses give the court the tools that it needs to arrive at a sound decision. The sixth methodology, I think, would be supplying empirical data informing one or another question implicated by an appeal. Some of this touches on the same sort of social science tools, but what does polling data say, for example, right? What have studies shown with respect to the legal question at hand? Have there been, for example, peer-reviewed papers that talk or address the particular issue? What is sort of the prevailing view in society? Like, how does the public regard the issue generally? A lot of this may not, some of it may be scientific, but some of it also may be sort of anecdotal, which I think also has value before the court. But again, the goal here is, I think, to provide as many different avenues and as many different perspectives for the court to view the legal issue, so that your brief is not just another Me Too brief that the court is considering. Seventh would be conveying instruction on highly technical, scientific or specialized subjects that would be sort of beyond the bailiwick of the court. You'll often see this, I think, in maybe patent cases or sort of highly scientific intellectual property cases, where it's really just sort of beyond the expertise of the judges. One thing to remember too about appellate judges is that although they are generalists as a practical matter, because there are a variety of cases that come before the courts, and throughout that process they sort of gain knowledge and a degree of facility with a wide variety of legal issues. That said, the judges that are hearing these highly technical and specialized cases, many of them don't hold specialized technical degrees. They're not chemists, they're not electrical engineers. And so having briefs that really simplify what can be a very sort of technical or scientific argument, and really sort of lay it bare before the court and break it down in a way that's easy to understand and that also provides an additional perspective, is a valuable tool, and I think one that would be additive to the amicus process. Finally, would be identifying how other jurisdictions, how other cities or states or even foreign countries have approached one or maybe another aspect of the legal question or the regulatory challenge. it's interesting because I think judges generally like to know that they are making a decision in good company. I think it is reassuring to a certain degree to know that the decisions that you're making are not so far afield from mainstream legal jurisprudence. And so one thing that an amicus can do to sort of buttress their argument and to perhaps to give the judges a quote unquote easy out is to say, look, your honors, here is what has transpired. Here is what has happened in other jurisdictions. Here is how other courts that are facing similar, if not identical circumstances have ruled on those issues. And even if it's not identical, if it's analogous, here are the issues that the court has considered. And I think you can use that same approach, whether the decision is one that favors your case or one in which you're trying to attack the opponent's case, to sort of say, here is how other jurisdictions, or here's why other jurisdictions may disagree with my opponent's view. So I think these 8 practical tips really provide sound guidance, really, I think, a wise way to approach amicus briefing, and to really sort of have a circumspect view about what are some of the best ways to draft an amicus brief. Not surprisingly, in the Seventh Circuit case from which these tips come from, Judge Scudder explained that the court did in fact find that the 3 amicus briefs before it were additive. They did add something new that could help the court, even though, and this is key, even though the briefs included some unnecessary and unwelcome, although perhaps inevitable, repetition, right? It's important to remember that even though the goal is to be additive, the goal is to provide something new to the court, that's not to say that an amicus brief necessarily needs to be wholly bereft of any of the other factual details, or to avoid, at all costs, repeating any of the underlying facts. I think those things help to provide context to the court, and some of it is inevitable in the course of your representation. But ultimately, I think the gravamen, the core and the crux of the amicus brief should be something new, should be something novel, should provide the court a new lens through which to view the case. This Seventh Circuit case I think it's interesting and particularly useful for litigants, because as a general matter, as sort of recounted above, the federal rules do not provide sort of clear guidance on what factors courts will consider or find most useful in amicus brief drafting. There's sort of a baseline about, sort of providing information on why you're drafting the amicus brief and what your interest is in the case. But there's really sort of a paucity of guidance, I think, out in the federal court system regarding what courts are looking at. So I think this is welcome guidance, and I think guidance that practitioners of all stripes and across the board in all countries can adopt and take to heart and implement in their own legal practice as they consider the drafting of amicus briefs. And with that, Jeremy, I'll turn it over to you.
Fantastic. Thank you so much, Dwayne, for that great overview and some great advice and perspective for people with those 8 tips. One question for you before we get to the question and answer portion of today's conversation. Have you seen anywhere those 8 tips summarized online, or are we able to steer everyone to an online copy of that court decision where they may be able to see the way that's presented by the judge himself?
Yes, I will post in the chat the actual citation to the opinion, and
Perfect.
you can can check that out at your leisure and convenience.
Excellent. Thank you so much, Dwayne. I think that would be useful for everyone to have. And thanks to everyone who's been offering some interesting insight into our polling questions as well. It's really useful for us and hopefully for you all to see some of the answers from your colleagues here on the prompts here. We are excited now to invite into the conversation someone who is introduced to me as the advocate who has filed the most amicus curiae in Rwanda under the new opportunities to do so, and one of Rwanda's outstanding young attorneys. It is a pleasure to introduce into our conversation Florida Kabasinga. Thanks so much for joining us, Florida.
Thank you, Jeremy. You're very kind in saying a young attorney. I'll take that for today. So thank you so much for inviting me. I think maybe I'm here to share experience with my fellow lawyers in Rwanda, especially practical experience that may be of help for those that are thinking about filing amicus briefs. And let me excuse myself. I will just continue calling it friend of the court. I have never been able to pronounce it right. I'm sure so many lawyers have the same problem like I do. So I have appeared as counsel on behalf of friends of the court a couple of times before the Supreme Court and the Court of Appeal. And I have also filed constitutional challenges where friends of the court have appeared and given their expertise that was very useful to the court in making its decisions. And I've also filed cases on behalf of a client in lower courts, which was spoken about in the previous discussion, where amicus and friends of the court appeared. So before I go into this, may I say that it's a very, very opportune moment for us to take these proceedings and take them before courts of law in Rwanda, because they create great jurisprudence. And I will explain why sometimes, not just the bigger picture, but you go into the court to provide some kind of expertise that ends up creating other benefits that impact the larger practice in Rwanda, which is a great outcome. So courts, especially the Supreme Court and the Court of Appeal, are very, very open to having friends of the court in Rwanda. It may seem like a novel idea. Maybe lawyers are not taking this to use it a lot, simply because maybe it hasn't been part of practice for a long time yet. But I will say that the judges and the courts are very interested. And I think last time we had a discussion, somebody asked whether the bar is set extremely high to appear as a friend of the court. So far, it is not. As long as you demonstrate expertise and you demonstrate that you are going to provide value addition to the proceedings. And what Dwayne said during his presentation is very, very true of practice in Rwanda as well. If you are simply coming to repeat what the others, for example, what the litigants have already put in their briefs, the court is automatically going to decide that you're not bringing any value and will not allow you to come as a friend of the court. So in sharing my experience, I'll talk about some of the cases, and thereafter I'll explain lessons learned that can be useful to any organization that is interested. The reason why friends of the court briefs are filed mostly in higher courts like the Supreme Court and the Court of Appeal is because they're mostly filed for public interest. So these normally come, all the way up in the higher courts, but nothing in Rwandan law prevents these friends of the court from appearing in lower courts. And we'll talk about the case that happened at the intermediate court, which I filed on behalf of clients, in which friends of the court appeared, and their arguments were actually very useful for the court in determining the issue. So the first case in which I appeared as counsel was the case of Esther Nibajinama before the Supreme Court. This was a case that involved infanticide. The accused had been convicted for life for having murdered or killed her child right after it was born. And when we came on board, I was counsel for an organization called Women's Link Worldwide, which works in the field of reproductive health all over the world, mostly in Latin America. And in Africa now, it has done some work in Uganda and in Kenya. And I think it has presence in Spain as well. So they asked me to represent them. And when we looked at this case, there were some things that were quite surprising. The first one was that this young woman basically probably had mental health issues because during her interrogation, she did mention things like she felt she had some kind of this is going to sound very strange, but she said she felt like a snake was leaking inside her brain, like leaking her brain or something, which to me was a red flag that she probably needed some mental health assessment. And she didn't have a lawyer at the beginning. And so the first trial, she obviously got convicted. And then she must have gotten some kind of advice that probably wasn't from a lawyer. She then writes a confession letter that is used during the next proceedings. And then she was convicted again. And she got life imprisonment again. And then when the case eventually got to the Supreme Court, this friend of the court, the Women's Link Worldwide, got involved. And so they got me on board. First thing you have to do as to get admitted as a friend of the court is to apply to get that privilege. It's not a right. And in so doing, you have to explain why you think you should be admitted. Among the things that you have to clearly state is what you're going to add to the court, to the proceedings, to the issue at hand, what your expertise in that field is. And therein, you'll put the expertise, for example, if it's an organization, of that organization, its experience in that field. Has it appeared as a friend of the court in different jurisdictions? Has it had decisions in regional courts from its contribution as a friend of the court? Has it, what kind of work has it published, reports, has it done studies? So you shore up your expertise such that your contribution to the court becomes quite obvious. So what we did in this case is to apply and demonstrate the expertise of the organization, and also the expert who would come and actually represent the organization in court. And then as local counsel that was assisting in this matter, I looked at our laws and how they can be used to argue for, for the, what we were looking for in this case. So one of the things that I insisted on including in the brief is that the young lady needed to have had counsel right from the beginning, which is not an argument that was actually raised by her counsel, because by the time she got to the Supreme Court, the Bar Association had already appointed legal representation. But having obviously analyzed the case file all the way from the beginning, her representatives obviously decided that she'd confessed, and were simply arguing for mitigating factors for her sentence to be reduced from life imprisonment to, I think, 20 years, which is what the law at the time accepted. So we argued that she didn't have counsel, and yet Article 39 of the Criminal Procedure Code at the time provided that the Bar Association should have been contacted and provide legal counsel. So we argued that although it wasn't possible for everybody to be provided counsel and to be represented, for cases that attract a high sentence, obviously we requested the Supreme Court to consider ordering that that article is always enforced, so that from the beginning, when you're accused of these cases, you have legal representation and good legal advice. And the Supreme Court actually did decide on that point. Although they did not completely exonerate and acquit, she was handed a sentence of 10 years, and a decision was rendered to the effect that cases that attract high sentences should have legal representation from the beginning. So I think that was a landmark decision that came out of arguments of a friend of the court. So the lesson here that I learned is that you can impact and create jurisprudence in the right direction if you set your mind to it. Many lawyers have asked me if I get paid to file constitutional challenges, because I do it quite a bit. These cases are always filed in the interest of the public, and so friend of the court briefs. It's work that is mostly pro bono, but it serves a useful purpose, because what comes out of decisions creates jurisprudence that impact other cases and legal practice. So we realized during this proceeding that we applied, and Women's Link Worldwide, the experts are based in Spain and I think in other countries. So having them, coordinating them to make sure they come for the hearing was not something that was easy. So we realized that when you file an application and then you wait to have a hearing on whether you're admitted as a friend of the court, takes time, it takes resources, people flying in and all of that. And then it also impacts the schedule of the court, because they have to schedule hearings on admission to be a friend of the court, and also a hearing, the main hearing on the merits of the case. So what we decided to do in the next filing as a friend of the court is that we decided to be filing both of them at the same time. We filed the application and filed the brief, and this enabled the Supreme Court to actually look at what we had filed long before the hearing, such that at the beginning of the hearing, they had a brief hearing on admission. They had took a small recess to decide on or to deliberate on that application, and then eventually came back, and we had the hearing on the merits of the case on the same day. That way, it does not impact on the schedule of the court. It doesn't impact on the appearance of the friends of the court, especially the international experts, if you have any. It becomes easier if you progress and do it that way. And that is a lesson we learned that we implemented in the case of a human trafficking case, which we also appeared as friends of the court. And that is in the case of Clever Twagimuchiza. He had apparently trafficked 3 young women to Uganda, to the border with Kenya at Busia, where they were basically used by him and his wife to generate income for them. They had a bar And when the clients requested other services, they simply paid him or his wife, and those young women were basically trafficked. So one of the things that we did was to request that in such cases, the victims ought to be encouraged to file civil claims during the criminal cases. So eventually, I believe that must have happened because they were even called to the court to talk about their experiences, which was probably in the direction of what we had advised as friends of the court. In the case of the surrogacy case that we did in the intermediate court, that too we filed a case. We had a couple that was a client of ours that was planning to have fertility treatments, but they were not able to conceive naturally. And so family members had offered to be surrogates. And obviously, because we didn't, there was a law that actually allowed for assisted reproduction in Rwanda. However, there was no guidance or policy on that. So we had to go to court to ensure that even the wider implications of that, including when you have a child, that child is registered under the mother's name, meaning that the woman who actually gives birth to the child would have that child registered as theirs plus her partner. And the person who was offering to be a surrogate was actually married. We filed a case in the primary court, and obviously this was a novel idea, and we were told there's no law that allows that. And so we filed an appeal before the intermediate court in Nyarugenge, which ended up allowing friends of the court, including HDI, which deals with reproductive health matters in Rwanda. It's an NGO, and then the University of Rwanda School of Law appeared as well. And we had very, very good arguments and discussions. So what ended up happening is the surrogacy request was actually allowed. The couple was allowed that. But I want to sound an alarm on the impact of arguments by friends of the court. We have to be mindful of what the repercussions can be. Because during these arguments, one of the friends of the courts actually said that it would be a good thing for the surrogate to be allowed to breastfeed the child for 6 months before handing it over to the biological mother. And that became part of the decision of the court, although we had argued that the benefit of the child being breastfed by the surrogate are far outweighed by the repercussions on the child and the surrogate mother having bonded over the 6 months of breastfeeding to be torn apart. However, in deciding what to argue before courts with regard to friends of the court and what you expect from court, you absolutely have to be mindful of what the goal is and be strategic about things that you bring before the court of law. And in saying this, we did have long discussions on whether we should appeal that particular decision. And we decided not to for many reasons. We had been burnt in the primary court, and we had to look at the interests of our clients more than at that point, creating better jurisprudence. In any case, we thought, how was this going to be monitored? And having weighed that, we let it lie. But why I'm saying this is that sometimes we forget the context in which we work. While we have secular laws and all of that, we have very conservative Christian organizations that will come to court and make arguments that may actually result in decisions from court that create jurisprudence that makes the situation worse. So while weighing the need to progress things and to bring new ideas, we are completely mindful of not making the situation worse. One of the lessons that I learned is that you can create much bigger impacts on small things that you apply for during these proceedings. And one of the things that I realized that is going to be impactful is that we requested for protective measures to be applied to our clients in the surrogacy case, to be given pseudonyms and for their names not to be exposed, and encourage other lawyers to do this for cases, for example, for, rape and reproductive health matters and others, and for minors in every single case, such that it creates a ripple effect where this becomes practice, even if it wasn't before. So now I would want to go to lessons learned. There's a question on whether how people can get to know cases that are being filed in order to apply to be friends of the court. If you go to the Supreme Court website, you will see that they publish the docket, the monthly docket. And if you monitor it, you can know what cases are coming up and get interested and file applications to join as friends of the court. When you file your application, make sure that your expertise is obvious in your application, such that your contribution will be obvious to the court before you are allowed as a friend of the court. I mean, there's been experience where lawyers, simply by the mere fact that you are a lawyer, you think you have the expertise and you apply as an individual. And we have experience of rejections, and I think rightly so, because being a lawyer does not per se make you an expert in a particular field. So when you file briefs, I saw a question on how useful jurisprudence, international jurisprudence is in the practice of in Rwanda. I can tell you it's only persuasive to the courts, and they're very much aware of it, but they're mostly interested in regional practice, which is a question that we always get when we appear before the Supreme Court and the Court of Appeal in these matters. We are always asked for, I think, and it makes sense for context, what has been the experience of Kenya, Tanzania, and why would the experience of, for example, Panama be useful to us? So you must be prepared to contextualize whatever you are bringing before a court of law as a good practice or as something that should be adopted in Rwanda. Always try to tailor your arguments and to the context in Rwanda and how useful that would be. When you file briefs, make sure they're extremely detailed, do comparative analysis, use jurisprudence from other regional bodies, for example, and use instruments. Maybe this may sound very obvious, but use instruments of which Rwanda is a signatory, because some of them, depending on the hierarchy, would be binding on Rwanda. And the Supreme Court always really appreciates this. And the idea of providing detailed briefs is very useful because it cuts down on the amount of time you spend during oral arguments, which is extremely helpful in many instances, because the Supreme Court in particular, they are very, very, very detail-oriented, and they always come to the court very prepared. They have read everything. So when it comes to oral arguments, they really just simply want you to highlight any things you may have missed maybe in your brief, or to elaborate more if there's a need for it. But at the beginning of the hearing, they will do a detailed summary, which is a bit of a contradiction, but there you have it. That's how it is. And then they'll ask you if you want to add anything. So if you have already a detailed brief which has already been considered, it also helps the judges come prepared to ask you key questions that will guide their decisions, and for you to be able to bolster your written brief and not simply to start afresh bringing new arguments. I would also, one of the lessons that we learned is that even where you have friends of the court that are international, that are writing in English, that are writing in French, try to remember that the language of the court is Kinyarwanda, and what you're trying to do is communicate effectively with the court. So we have always translated the friend of the court brief into Kinyarwanda. It helps the judges in the drafting. It helps them in understanding what you're trying to communicate. Also we have decided that where we have international experts, we always bring interpreters in the court, such that it becomes much easier. And so it may sound obvious, but as a lawyer to a friend of the court, you must obviously bring this to their attention at the beginning, that they will need translation, they will need interpretation, such so that they make provision for it in terms of funding. So as you can already imagine, being a friend of the court is not something cheap, but it's something in the interest of the public. So many organizations, to me, should be becoming more active in this area and filing these briefs, particularly because our courts are very open to having them. And so far, on the previous discussion, somebody asked whether there is a policy on application and appearing as a friend of the court. So far, there's none, and for me, I see this as something good, because we are learning a lot, and it will help us gain experience and create a policy that is uniquely tailored for our system and our context and our circumstances. The other thing is that even when in cases where the court realizes they don't have the necessary expertise to determine a matter, the courts in Rwanda, particularly the higher courts, they are very active in seeking out friends of the court to come and help them explain certain fields and issues. So don't be reluctant or hesitant to go as friends of the court, to bring organizations to appear in these cases, because it's something that is actually welcomed in the courts in Rwanda. I think for the most part, I've touched on everything. So if I'll hand it back to Jeremy, and I hope sharing my experience is helpful for many of you. Thank you.
Fantastic. Thank you so much, Florida. We really appreciate your perspective and the great insight you are able to offer from some of your personal experience working on these type of briefs in Rwanda. A note now to encourage everyone to either type any questions that you may have for either Dwayne or Florida or both, or for others that are joining us in the group tonight. Please do add those into the chat box if you prefer. You are welcome to find the reaction button and select raise your hand, and we'll be able to call on you as we work through some of the questions we have this evening. One question I had for you right off the bat, Florida, was it's interesting to hear that the courts tend to give greater consideration to regional best practices and experience. Is that something that you think comes simply from geography and proximity, or are the courts valuing cultural similarities, or is there something deeper within the legal systems that is that's similar between Rwanda and neighboring countries?
No, I think what the courts are considering is the culture and geography, I believe, but they're not reluctant to get lessons from other countries that are far and wide. It's just that if there's any regional experience, they tend to see it as more of something to relate to than possibly an experience from somewhere else, although it hasn't stopped them on many occasions from taking lessons from other regions.
Thank you. In Florida, we've got some great feedback here from Mary saying, thank you so much for the presentation, just the perspective we needed. Thank you, Florida, from Moise, and thank you for the good presentation from Helene. We have Mary popping in with one question. Mary, would you like to take yourself off mute, introduce yourself, and ask the question?
Yes, thank you. Thank you, Jeremy. Hello, Council Florida. I just have a curious question. Is there a court fee that is needed when filing when you're going to be a friend of the court? And also, is it filed the same way we filed, cases through the ISMS? Those are only the two questions I had. Thank you.
So there is no fee because you do this in the interest of the public, and the court has been very clear on that. The other interesting thing that I can tell you, we had an experience before the Supreme Court where we did not file things. There was a mistake that we made and we were almost about to be fined, but because we were doing this in the interest of the public, the court did not fine us. So it's very interesting that happened. So there is no fees. Mary, what was the second part of your question?
Is it filed the same way? You know how we file cases in the ISMS. So does it go through the same process?
So normally, because you have to initially apply to be a friend of the court, so you cannot be in the ISMS, so you don't file the normal way until you are admitted as a friend of the court. But when I said that you should always file your application along with your brief, so normally what we do is we take the hard copies or email them to the Supreme Court since COVID, but normally we take them to the court registrars and they upload it in the system on our behalf. But if you apply and wait for you to be admitted, then you can do the rest of the filing by yourself online the usual way.
Thank you.
Welcome.
In Florida, you're usually filing in both English and Kinyarwanda at the same time?
Yes, we do that when we have international experts involved, because the drafts are done in English because that's the language they understand. And so when they give it to us, we've advised that we translate, we have a translation service done, and we file both of them in the court. And what has happened is, which I think should also be done on a regular, is that these briefs are available publicly. So if you have a similar case, I honestly don't think there's anything that can stop you from using that brief in another similar case before a different court in Rwanda.
Interesting, very good. One question that I had for both of you from your different backgrounds and experiences is you both said courts really want to prioritize knowing that the perspective that a non-party brief is going to bring is going to be novel. And so how, in practice, how do attorneys, how does this tend to, how do people, learn about not just the current cases that they might have a non-party stake or interest in, but how do they know that they're filling a gap? Is that courthouse scuttlebuzz? Is that in conversation with attorneys who are parties to the case? Or are there other ways that attorneys are making sure that the arguments that they want to raise are the novel arguments that aren't already being covered and addressed? Florida, could we start with you?
So usually what we do before we make this application, I get all the information that is in the case so far, what the parties have filed, what they're saying, and all of that, and it helps you inform yourself of what new thing you can bring to the table that can assist the court in determining the matter. And always we have found that there's something to add, especially because in the context of our country, sometimes we don't have inclusion of jurisprudence from other countries. We don't have inclusion of international instruments that are key. We don't have maybe use of similar decisions in other countries. So we do bring that kind of expertise, which enriches the argument usually.
I think one way to do it, one way that I've done it in practice is, and one thing I certainly encourage is to coordinate the drafting of the amicus brief with counsel on the merits. And what that means in practice is that you would get a copy of the merits brief in advance of it being filed, and you have a chance to review the arguments, you have a chance to take a look at the analysis, and certainly in consultation with merits counsel, I think it is useful to have a discussion about what arguments they intend to raise and where you can add value and fill gaps. Again, as I pointed out earlier, briefs do have page limits, and oftentimes counsel will want to focus their energies or attention on a particular legal issue, or maybe raise something only sort of tangentially in a footnote. And that's a ripe opportunity for Amicus Curiae to add value and to maybe expound on that, or to discuss an issue that's just totally not explicated on in the merits briefing. So I think coordination is key, communication is key with merits counsel, and that will certainly give you a good sense of an issue to discuss. Something else to do as well would be to take a look at prior opinions from the court or from the judge and how they've treated the issue. Sometimes the court may leave breadcrumbs in the opinion, so to speak, clues or hints as to the issues that they may find dispositive or consequential in reaching a decision. And those could provide useful hints in terms of where you might want to focus your analysis and what the court might find particularly useful. It may not always be the case that merits counsel will discuss those issues, but there are a host of different ways to add value. As Florida correctly, I think, points out, there's always something new that can be said, and there's always value that you can add. I think it just requires a bit of research, a bit of effort and communication with merits counsel.
Thanks, Dwayne. That's great. Florida, do some of those points seem to resonate in the local context here in Rwanda?
Absolutely. So what happened with, for example, the surrogacy case, we are the ones that invited HDI to come and join the case. And I can say for a fact that we did coordinate and it helped. It was very useful.
Jeremy, one follow-up, if I might, because there was a question I see in the comments that may have been sent inadvertently privately, but it's regarding the use of amicus briefs at the trial level, and when you have a jury trial in American jurisprudence, and just what the implications are there, and you know, if there is precedent for usage there. I haven't seen amicus briefs used at the trial level, particularly when you have a jury trial. District courts certainly have, trial courts certainly have discretion to entertain amicus briefs. At least over here in America, the rules of engagement for trial courts aren't as well established as they are for the appellate courts, and oftentimes the trial courts will sort of borrow the rules or procedures from appellate courts to determine whether they want to entertain an amicus brief. But in a jury trial, no. Certainly for a bench trial, perhaps if there is a legal issue that needs to be briefed, I think the court retains discretion to entertain that amicus brief. But in all instances, ultimately, you know, particularly to the extent that the trial court is borrowing the language and the practices from appellate courts, you're going to want to state in the amicus brief or demonstrate to the court why the filing of the amicus brief is desirable. It's also going to have to disclose, you know, what your particular interest is in filing the amicus brief. Why are you interested in the outcome? You know, is it the case that you tend to represent clients that have legal issues that may be implicated by the ruling before the court? Is it because you have a pending case in another jurisdiction that could be influential to the court? So those are the sorts of things that bear on the extent to which I think a trial court would be inclined to permit an amicus brief.
Great. Thank you so much, Dwayne. One question suggested from one of our audience members is thoughts that you both have in terms of resources beyond the recommendations that you've already given for the drafting of good briefs. Dwayne pointed out a specific US case that offers some guidance that folks can look at. But are there things that you both hold as really good examples or templates, or even resources or places where people share best practices or ideas or suggestions on the technical side of drafting amicus curiae or other briefs?
I would say two things in response to that. One is that I would say with the, you know, sort of rise of the internet and the democratization of information and legal information at that, it's very easy, and I think the information is accessible to simply, you know, peruse court filings, other cases where there are notable sort of, you know, luminaries or appellate advocates that regularly appear before the courts to draft amicus briefs, and to take a look at how they structure their briefs, you know, how they develop the arguments, and how they sort of fill the gaps. There's really just sort of an abundance of material out there that that attorneys can sort of use to their advantage to buttress their practice, to improve their advocacy skills. In addition to that, there's a host of literature out there as well, sort of formal literature that you can read to provide guidance on, I think, appellate practice generally and amicus drafting. There's one that I use in my own course at William and Mary by Scalia, Justice Scalia and Brian Gardner, that talks about the best ways to sort of make your case before the court. It's called Making Your Case. It's co-authored by Anthony Scalia and Brian Gardner, and it sort of lays out best practices for brief drafting, how to craft the analysis, things to keep in mind. So those are the two that are sort of top of mind, just the abundance of resources online, and then also sort of looking for more formal guidance in literature that's been written.
Thanks, Dwayne. Anything you'd recommend from your experience, Florida?
I mean, there's not that many of us that have done these things in Rwanda. So there is a resource in having people that have done this before and that are willing to provide any guidance. And like Dwayne said, you have so many resources online. And for me, what I would advise is that when you approach organizations on an issue that work on an issue that you're interested in, to appear as a friend of the court, those organizations normally can find the right expertise to help you with putting together a detailed brief as an amicus. So the resources in terms of lawyers here that have done it before, because we do this, it's really in the interest of the public. So once you've done this, it's a passion that you're willing to share with others. And of course, organizations that are interested in different issues do put aside resources to actually bring on board experts that can craft great friend of the court briefs.
Great, thanks, Florida. Dwayne, have you ever heard stateside about any law clinics or similar that might connect with international attorneys who are looking for feedback or assistance in drafting Amicus Curiae briefs? I'm just guessing here.
None that come immediately to mind. I know at one point Howard University School of Law, from where I graduated, had a human rights and globalization law review, and also a civil rights clinic. Oftentimes these organizations will partner with public interest entities, be it international or otherwise, that have interests that may be implicated by the case that's pending before the court. And so that is probably the closest nexus, I think, to international participation in a local case. But it's a good point, because I think that clinics generally are often looking for opportunities to provide teachable moments for the students. And so I think clinics would welcome sort of inquiries from international bodies and folks who have interests that are being implicated from a local decision here.
Great, thank you. And Florida, is that a part of legal education here in Rwanda at all? Are there clinical opportunities where maybe law students would be looking to work on projects and help assist with Amicus Curiae and public interest?
To be quite honest, I think this is an area in Rwanda that can do a lot in this regard, not just for Amicus, but for all kinds of improvements in resources. So there are law clinics, but I've heard of, for example, one at the University of Rwanda. There was one in Iraq at the law school, but some of them are dealing with specific issues. But I think it's it would be a great opportunity for partnering with others that would be a resource, and also for universities to get experience. There is a great opportunity in that. I think it's something that would be welcomed by law schools.
Great, thank you so much. Great perspective here. I don't see any more questions in the chat, but do feel free to jump in with any last minute questions. Now it is a pleasure to re-invite onto our digital stage Moise for a few words on behalf of the Rwanda Bar Association. Moise?
Thank you, Jeremy. I wanted to say a few words in terms of closing remarks in as far as this training is concerned on behalf of RBA. I won't take too long because this is only to say thank you and to thank the Embassy of the United States in Rwanda, and to also do mention that in this area of capacity building and maybe any other area we can explore, we look forward for strengthened partnership with the embassy going forward. And we also take this opportunity to thank the ambassador that is now present. I can see that he's joined us. And you know, we engage you, we have to engage each other going forward and see how we can explore new areas of partnership between the embassy and the Rwanda Bar Association. This is beneficial for our members, and we think it's just a start now, and going forward, it should be something that we are going to be working on and making sure that it's we keep getting this kind of insights from people like Dwayne Sam, and we also share our experience to our end, and I'm sure he also learned from us from the practice that we have here in Rwanda. So this is a kind of exchange that we value, and the whole purpose is to be informed professionals that can help this justice to progress in one way or the other, which like most of the people needs in the promotion of the rule of law. So I thank you, and I look forward for partnership going forward between the two institutions. Thank you.
Great. Thank you so much for those kind words, Moise. It certainly is a pleasure on the public affairs side to be able to facilitate some good conversations and exchange and dialogue between experts in the United States and experts here in Rwanda to help increase the mutual understanding between our countries and the people of our two countries. And specific to the embassy's goals on improving and increasing, expanding democracy and human rights and access to justice in Rwanda, it certainly is a valuable conversation to take part in and continue to work with you all on. We certainly appreciate the role that Rwanda's advocates and members of the Rwanda Bar Association play in that process, as well as civil society organizations that are interested in continuing some of those same conversations and continuing and expanding some of that same public interest advocacy. And without further ado, it is a pleasure to introduce Ambassador Peter Vrooman into the conversation for a few concluding remarks on our side as well. Ambassador, thank you so much for joining us today. Over to you.
Well, thank you very much, Jeremy. And you're not only a public affairs professional, but you're also trained in a multilingual public affairs professional, yes, and also a card-carrying Bar Association member and legal lawyer. Now, that's what's dangerous in having ambassadors, diplomats like myself, who are not. So we dabble in and are interested in, or I am at least, in the profession of law. In fact, I think I would have benefited to have gone to law school to become more articulate at making my case as a diplomat, a policy person, and to have the rigor of legal thinking. But luckily, I have lawyers on my team who can give me some Amicus Curiae briefings to keep us smart and to keep me going in the right direction. I really want to thank the Rwanda Bar Association, its members, both Moise and Florida, for contributing the Rwandan context and perspective. And I know from having met with many of your lawyers and judges, from the appeals court to the Supreme Court, and knowing a lot of the legal programs and rule of law programs that have bridged the Atlantic and bridged the continents of Africa and the United States and Americas by having exchanges to talk about issues that are important. And that could be the program that I believe the University of Ohio has done with many of your prosecutors, public defenders, and judges on issues such as stare decisis. And I apologize for my Latin, it's a bit rusty, but the idea of precedent in building up cases, important for both defendants, litigants, and for prosecutors, defense lawyers to make their case in a way that is able to be compelling and builds a Rwandan case law precedent that can be utilized for advancing the rule of law in your country. Similarly, I think the Amicus Curiae approach, and I do look forward, Dwayne, I'll get to your contribution in just a moment, but your recommendations already I've written down, making your case. I had the pleasure of meeting Justice Scalia in Israel, where he talked about some of the unique aspects of the American system. And while he, of course, was, people had different views in terms of his judicial philosophy, but one of the things that I always remembered from Scalia was that the United States is a rare country in that people like myself, a diplomat, an ambassador, Jeremy as a foreign service officer, soldiers, statesmen, legislators, we swear allegiance not to a party or a person or a president, but to a piece of paper, a constitution. And that's something I'll always take away from Justice Scalia when I met him and when he spoke to his counterparts in Israel. Dwayne, thank you so much for coming and virtually. Hopefully we can make it possible so that in the future this can happen in person, but I know legal time and expertise is billable by the hour. So I think it's to everyone's advantage that we're able to connect you with lawyers, with the Bar Association, with practicing professionals to make the case about how Amicus Curiae briefs can be of assistance to a court and to be used by, in particular, defenders, but also potentially, I believe, by prosecutors as well. That contribution and the knowledge that you've shared and that I hope to review, I apologize I didn't join earlier, I had a conflict, but I do hope to be able to review the YouTubes. I think those would be a great resource, not just for the non-legal professionals like myself, but for lawyers who want to get some insight that you've shared and been so generous with sharing with your Rwandan counterparts. And I think that, the corpus of international law, and I contributed to it in some degree when I worked at the United Nations in the Security Council in helping draft UN Security Council resolutions, benefits from having the insights from other people, whether it's a UN Security Council resolution or whether it's the case law that real lawyers get involved in your individual jurisdictions and learning how other jurisdictions do that. So I want to thank all of you for the work that you've done in supporting this series. I hope it will not only forge the context that we're happening right now in the sessions, but rather that they'll be able to influence and form connections between lawyers in the future. And that in itself will help create the sorts of exchange that are so vital to enhancing international understanding and building rule of law, both in the United States and in Rwanda. And that's a key point I want to say. You know, we just faced, we've heard, I heard this morning, the verdict in the George Floyd murder case. And I sighed of relief. It's not enough because the justice that may have been done or may be done in the sentencing process will not bring his life back. But nonetheless, it's important and educative for the entire American community, whether you're a police officer, whether you're a Black Lives Matter protester, whether you're any citizen of the United States. And I would say because our system is so open and often, well, it aspires to be open and transparent, but these cases make it clear that the whole world is watching. And when I was in Ethiopia, the judges that I worked with and helped connect with American judges, they and the diplomats that I worked with regularly, they were interested in what was happening in Ferguson in the United States. And just as your Minister of Justice and others are very interested in what happens in the George Floyd case. So the world is global, the world is virtual. We're having these sorts of interactions. They're happening all over the world, and people are watching what happens in courtrooms all over the world. So the visibility of your arguments and the visibility of arguments that buttress your cases in Amicus Curiae briefs are incredibly important. So I want to thank you and hope that this will inspire you to think about its relevance to your system, just as I know you're looking at other types of reform, arbitration, settling out of court, those types of situations, to make your system efficient and to do things the way that Rwanda wants to do them, but mindful of best practices, international standards, international commitments and treaties, but also being aware of what and how the practice of law can improve through your efforts here in Rwanda. So thank you very much. Murakoze cyane.
Thank you too.
Thank you so much, Ambassador Vrooman. We appreciate your remarks there. Thank you for capping a really interesting discussion today about Amicus Curiae best practices in operation, both on the US side and here on the ground in Rwanda. In terms of follow-up going forward, please do feel free to reach out to the embassy. I've added my email address to the chat here if you have feedback about this program or ideas for program going forward. Thank you to everyone for participating in the polling. We've got some great ideas to take going forward, and I'm glad to see a 100% response rate that this training series last week and this week has been either very beneficial or at least somewhat beneficial to you as you look at the opportunity for using Amicus Curiae non-party briefs in your legal practice going forward. So on behalf of Ambassador Vrooman and everyone at the embassy, and with great thanks to our three speakers and our counterparts at Rwanda Bar Association, thank you so much for joining us for this series. We'll make sure to post this soon, both on the embassy YouTube page, as well as on Rwanda Bar Association websites for you to share with colleagues who might find value in this program as well. Thank you so much, Dwayne, Florida, Moise. Thank you so much, Ambassador and RBA. And thanks everyone for joining us this evening. Take care and good luck with your Amicus Curiae advocacy going forward. Thanks, everyone. Bye-bye.
Thank you, Jeremy. Bye.